copyright, this is going to be the body of law that is the most important to you as an artist. There's a whole entire statute, there's a whole entire government office called the Copyright Office, and the goal of these laws and that office is to protect artwork, original works of art. So, and it came out seeing that there's an incredible amount of value in protecting innovation, and that helps the society, helps our economy, helps just us become better people. So this is kind of how copyright law started. And so it is the law for you as an artist, okay? That's the circle C, you've seen that. So what is a copyright? The moment that you finish a work of art, you have created a copyright. So the moment that you take that picture, right, taking those pictures, you're creating hundreds of works of art that have copyrights, okay? When you finish your painting, when you finish your sculpture, when you finish writing something, or it could even be a first version of something too. Every time you create something, you are creating a piece of property that has a lot of legal rights and power, okay? Think of it like you are owning real estate. When you own a piece of land, there's all these legal rights that come with it being an owner. When you create works of art, you're getting all these legal rights and protections instantly, automatically, when you create that work of art. So all you have to do is create the original work of art. That's it. You've done it, okay? And it's different than owning a physical piece of work. So when you sell your artwork, you are not giving up your copyrights. Those legal rights that I'm going to talk about will stay with you. The only way that you can actually ever give up those rights is one, they expire, which that means you've been dead plus 70 years, okay? Or two, you physically have to sign a written contract saying word for word that I am giving up my copyrights and transferring them to someone else. You can't do it verbally, you can't do it in an email, you can't do it in a text message, you have to have an exact contract saying that. So when someone buys your painting, someone buys your sculpture, print, whatever, photograph, these rights stay with you. All they're getting is physical possession of the artwork they bought. That's it. Okay. So this is an artwork from Jessica Bell. I'm sure many of you guys know. And so it's got to be original work of art that you've created in a tangible form. That means people can see it, they can touch it, they can watch it, they can read it. Okay, it cannot be in your head. So that's why I also used her work of art here, because it's a bunch of heads. but your ideas and sort of these concepts that you may have for future works of art or for different films or things like that, none of that is going to really be protected until you get it out of your head and into something that other people can see. Okay, so it could be a performance, it can be, again, visual art as painting, photography, sculpture, things like that. So once you get that out into the world, people can see, experience it, there's your copyright. Okay. Something that's really important, and I'm going to talk about an artist, can't give his name, but talk about a situation here, is your copyright notice. This is something, if possible in your artwork, always have on it. Put it on the back of the canvas, put it on the back of the photograph. Always, always, always put this on your website, at the bottom of your website, and you can put it in your in your Insta description. You could put all images copyright, copyright 2024, your name. Okay, so this puts the public on notice that you're claiming this as your original work of art, and that has a lot of legal benefits down the road. So if someone infringes your art, like someone goes on your Insta account and starts copying things, you've put your copyright notice on that Insta account. First of all, they shouldn't be doing that anyway, that's wrong. You've also put that notice so that if someone later says, oh, I didn't know that they were owned by you, or I didn't know it was copyright infringement, no, you had the copyright notice. That is not, so to the extent, if you're doing a mural, find somewhere that you can put that. And it doesn't have to be, a big part. Just find somewhere that's maybe discreet, somewhere that it kind of fits. And I mentioned this specifically with murals because I had an artist that I work with just a few years ago, and he did a more well-known mural in Austin. And you go into any, shop in Austin, like gift shop or whatever, and you can see it's on coffee mugs, it's on t-shirts, it's on sweatshirts, it's on posters, it's on canvases, it's keychains, whatever merchandise you can see, it's on it. He has not made a dime off of that. Nothing, okay? And it got And he wasn't really paying attention to what, like, he painted the mural and kind of moved on, okay? And he did not put his copyright notice on the mural. So a very famous TV show found his mural, and they used his mural as set design, as a desk. It was a talk show, okay? It was the desk. So Lady Gaga's sitting next to it with her feet on it. You've got like Willie Nelson, like you've got all these huge celebrities being filmed right there with his mural. And so that's what he noticed. He's like, a friend called him and said, hey, I saw your mural on blah, blah, blah show. Did you know that? He was like, what? So we called the TV show, and TV shows have special lawyers called clearance lawyers. These are lawyers that actually have to get copyright permissions and licenses to use any artwork as set design. TV shows, movies, things like that. And also like music, played, stuff like that. So I called, and thank God their lawyer was a very nice person, and the specific individual show was really cared about artist rights. Because they go, actually, we've been trying to find this guy. We want to pay him. We can't, but he didn't put his copyright notice, and the building had like changed hands, and the building owner didn't know who the original artist was, right? They was like, thank God, we found you. Yeah, like, where do we cut the check? It was that simple. They were trying, now that's a good situation. It could have gone a lot worse because they actually had a very good legal argument, and they could have said, you know what, we don't owe you a penny because you never put your copyright notice. So we were innocent infringers, and we actually tried to find the artist and tried to find you. So always use your copyright notice to the extent you can. Like if it's sculpture, you can kind of put it on the bottom. Sometimes you can't use it, but to the extent you can, put your copyright. All right, okay, so what are some protections you have? These are what are called economic rights. And at the bottom, there's some moral rights. So economic rights means you can make money. So you have the exclusive right to copy your work. Even though you've maybe sold one edition of it, you can make other copies. You exclusively have that edition. You can make derivative or similar work, so things that are sort of building, right, and expanding that body of work. You can license it and give your right to others as well. That all stays with you. You also have the exclusive right to be credited as the author and the artist, the original person that created that. So that is actually, you can sue people if they try, not only for stealing your work, but it's also because you're saying you are the author, not me, right? And you also have the ability to prevent the destruction of your artwork. A lot of people know that. So, and this happens a lot with murals as well, too. There are something called moral rights. It's called the right of attribution, that means the right to be attributed and credited as being the author, and the right of integrity, the right of keeping your work intact and the work of not being damaged or destroyed, things like that. If your work is damaged, this happens a lot with public works, like say you're doing a public sculpture, public mural or something, and it's damaged by weather or vandalism, things like that, you can actually say, that's no longer my artwork, and what's called disavow, and say, I'm not associated with that, because maybe you don't want to be because it's not been kept in a condition that you're really proud of anymore. So you can do that. So how long does your protection last? We're going to talk about two. We're also going to talk about work for hire, not work for hire. So mostly for what you're going to be using, what's most common for you is going to be not work for hire. So this is you creating artwork on your own. You're not creating it for commission, and it's not, you haven't transferred the copyright. So when you create artwork on your own, your rights, those economic rights and those moral rights, will last your entire life plus 70 years. So that means your heirs will have 70 years to continue to get money off of your artwork. And then if it's a work made for hire, so this is someone who has commissioned you, and there's a written contract saying you're either transferring the copyrights or you creating this, they usually say it's a work made for hire, then you're going to have the lifetime of that protection will last 95 years from the publication. I'll talk about what publication means, or 120 years from the artwork creation, whichever expires first. This time period here is thanks to Mickey Mouse. Okay. So that's why it's kind of strange. It's got a little different twist to it. They have obviously a lot of artists that work for them as work made for hire. They wanted to kind of figure out a way of having longer, extending out the time period as well for their protection. So publication means you have distributed copies of your work of art for the purpose of sale or transferring ownerships or renting or leasing, things like that. So you could be in a situation where you have not published the artwork, but you've created the artwork. Performance and exhibition alone may not be considered that you've published the work. You may just be sort of like, exhibiting it as well. All right, so moral rights. So that's going to be the right of you, your attribution, so the right to be credited as the author, and then the right of integrity of your artwork. That's only going to be as long as you live. Sorry, that is not as long. That is not the 70 years after you die, and it's only available for visual art as well. It's not available for music, audio. So that's something. It's something unique to visual art as well. So a little bit more about moral rights here, the two. I put the girl that you've probably heard of this statue before on Wall Street as well. And so this particular work of art, believe it or not, was actually subject to a potential moral rights issue. This artist, I feel really bad for her, is still dealing with some legal rights with creating this work of art. But this particular case involves when this statue was placed in front of that bowl, right? The artist that created that bowl said, "You're violating my moral rights. You're violating my right of integrity because you're destroying and altering the message of my work of art." Because now that you have the two works of art together, right, they have a totally different meaning than when you had just the bowl itself in front of it. So, that was a case, and it was not well received publicly as well too. Like, the message behind this little girl is so important. It was so important at the time too. And you have a statue that was created by the female artist there, and then you've got a male coming in and saying, "You're ruining the integrity of my work of art," and it did not look good, especially the subject behind creating this sculpture. And so that artist eventually backed off and did not sue for moral rights, but he was threatening to sue for moral rights and saying, "You're violating my moral rights when you're changing my work of art." Murals particularly, if they're going to be destroyed or painted over, that landowner is supposed to contact the artist, any sort of like public art or art affixed to a building, things like that, and contact the artist and give them 60 days to remove it. And however, the artist will have to themselves pay for that cost to remove it. So sometimes it's just not practical. Like if you've painted on brick, right? Like you're going to take out all the brick and then like replace it all, right? Like you can't do that. But that is something that is a right that you have, and not a lot of people realize that. Not a lot of real estate developers realize that too, and they don't know that, oh, I'm supposed to contact someone about this mural. I can't just paint over it. Okay, so 5 Points is unfortunately no longer there, but it was considered sort of like this museum of street and graffiti art. It was owned by real estate developer, and he'd actually hired a curator and had like programs and things like that where you could come, and it was like you could tag, incorporate your art into this building. Incredibly well-known street graffiti artists were part of this. It was like being able to be part of this was very much considered like getting into a museum. The developer decided he wanted to sell the building, and in order to sell the building, you have to whitewash it, to paint it all white. Okay, and the developer knew that he had to contact, because there were artists that probably would have paid to get their artwork out of here, like would have paid to get the bricks and redo the bricks and things like that. And a lot of these artists even had, some of them had like copyrights registered as well for this. So this developer knew that this was not right to do, and then was getting sort of legal actions filed against him to prevent this. And then he went ahead and did it sort of in the middle of the night, painted over everything, destroyed all the art. A bunch of artists banded together and sued, and they won. And they won a significant amount of money, and we'll talk about those damages, because this was an intentional infringement and this was an intentional destruction of their rights of integrity, of the right of their artwork, and not giving them the opportunity to protect their artwork. So, and he was fined, I think it's close to $7 million that he had to pay out to the respective artists who banded together to do this. But so it was also a huge message too, that like you can't just go in the middle of the night and paint over someone's artwork like that. So employees versus contractors. We're going to switch gears and then we'll go back. We're going to talk about copyright registration. When you are doing artwork as part of your job as a W-2 employee, okay? So if you are in a job that uses your creative skills as part of the duties, say you're a graphic designer, right? You're working for a video game company, or you're in marketing, right? And you're creating things with graphics and design, right? Everything that you create as part of that job when you're a W-2 employee, and it's part of your, part of the scope of your services, unfortunately, that artwork will be automatically owned by your employer. If you are not a W-2 employee, if you're a contractor, it's the opposite. Everything you create as a freelancer and as a contractor your copyrights will stay with you. They will not be given to that company hiring you unless there is a written contract saying otherwise, saying you're transferring, saying the work you're doing, they will own the copyrights. This is an issue that a lot of companies don't understand. So if you are hired for a specific job and you just get this one sheet that's like, here I'm paying you, here are the due dates, here's what you're making in a description, they've just paid you to create a work of art, but they haven't given you the copyrights. So let's say they now want to use what you've created in a TV commercial. They have to come back to you and get your permission for that. If they want, or it could be a variety of things. So it kind of depends on what the scope of your relationship was with them. You could end up giving them perhaps maybe implied license for some use of that work of art, but it's messy, and you could end up with a lot more rights that they did not realize that you still kept. And so it's something that when you are being commissioned for a project or doing contract work and creating works of art, think about a discussion of, are you keeping the copyrights with you and just giving them physical possession or some limited license or permission to use the artwork in somewhere, or are you actually giving them the copyrights themselves? So those moral rights, those rights of integrity, the rights of, the economic rights, rights of attribution, all that. Are you giving that away? There's a misconception too that some people think because I have hired you for a project and I've paid you money that I get the copyrights. No, there has to be a writing saying that. And so if there's any confusion, if you're doing something that will have a future use, like you're creating a graphic that's going to go on, a t-shirt that this company is going to sell. What is that? That's the time to have a discussion of, are you going to pay me a royalty, like a percentage of, how much of these shirts you sell future on? Like, am I just giving you a license, or am I actually giving you the copyright? So then they have now the economic right to make copies and reproduce it. If you're being commissioned for, say, someone that's in private, going to commission work for, a friend, family member, collector, things like that, or maybe you're doing some work for, public work, public art, things like that. Typically, they don't usually try to get the copyright from you. They just want the work itself. But that's going to have to be something in the contract. This is a work for hire copyright transfer clause. Yes. And this is one that I've drafted this one. And a lot of times they're a lot shorter than this, but this is one that covers everything. This is one that's saying it's a work made for hire. This is one that's saying I'm transferring my copyright in case that falls. It goes very, very clear. So if you're reading a contract and you see this clause, see anything in there that talks about, if you see that word work made for hire, that is a sign to you that they are trying to get not only physical possession of the artwork, but also the copyrights and those economic rights as well. You'll see this work for hire under copyright law, work made for hire too. You'll see that, and that is the goal of that, is to not only just get rights to the physical artwork itself, but rights to the copyrights too. I had a photographer call me just a few months ago, and he was doing a campaign. It was like a major makeup brand and was doing photographs and things like that. And they sent him a contract. They gave him like 12 hours to sign the contract before he had to start shooting. And it had something like this in it. And he said, I'm not giving you my copyrights. You're paying me to do the photos. And then once I know, then we're going to work out the price for you now to sort of reuse these commercially and things. Like, you're paying me for the photo shoot and create the photos. But if you want to use these commercially and these to be like all over the internet and on TV and commercial ads, that's going to be a different price. And we're going to talk about that. And the company said, okay, and this is all in email. Okay, yeah, we know we're just paying you for that. But the contract said this, said that you're transferring the copyrights. So he signed it, thinking he was okay because he had this email string saying, you know, we're gonna treat you right. We're gonna pay you more for the call it usage rights. He kept calling it usage rights. So he went back to ask him for that, and they said, no, read your contract. Your contract has a clause in there that says, and I'll talk about this too more, at the very end of the contract, it's called an entirety clause, and the entirety clause says this is the entire agreement. No, nothing verbal or outside, sort of like the four corners of the contract counts. So it didn't matter that he'd done all his due diligence and got these emails to prove him, you know, what he signed is the only thing that mattered, and not what that signed. Now, could he have fought this? Could we have brought a lawsuit and said, you know, it was fraud and they were misrepresenting? Yeah, but the cost of that was way, way, way more than what he was paid for the job, and it doesn't make sense. Like, it doesn't make sense on that. What makes sense is like, learn the lesson, don't do it again. You know, if they say that they're gonna pay you for the copyrights too, then that has to also be in the contract as well. You have created the work of art, and which has the copyrights, but the US has a very strange law about registering your copyrights. So you have these rights. However, if you want to sue to enforce your rights because someone has taken your artwork, you cannot do that until you have your artwork registered with the Copyright Office. It's a prerequisite. The frustrating part about that is I don't think this is something that is easily, you can learn about this easily online. I think this is really important, and it really affects your legal rights. And what it is the government wants you to know, give them just information of what you've created. It's like a library, think of it like a library, right? They want to know this artist created this artwork on this date, and that's what they want to know. They want this information to be cataloged, and it also helps with ownership too, proving like who owned it, you know, who actually originally created it, things like that. And so how you do that is by creating an account. You create like an online account with a Copyright Office, copyright.gov. You register your works. So there are forms. The information is pretty straightforward. The forms are a little, the portal's kind of outdated, so it's a little tricky kind of to sort of get in and get an account set up. But you pick forms for visual arts, or if it's like a performance work like choreography, there's a separate form, or if it's an audiovisual work, there's a separate form for an audiovisual work. If it's but like sculpture, painting, photography, prints, that's all under the visual art form, okay? Music's under a different form. It's $65 per application, but you can also do a group application of like 10 artworks of the same type that were sort of created in the same year, which are not published, right? And you can do those together under one application. Or for photographers, guess what? You have 750 works that you can do in one application. So yeah, yay! Yeah, that took a while to get through, but it's the process of, so if you find someone who has infringed your work and you do want to sue them, unfortunately, this is what you're going to have to get this registered. So the kind of information that's provided is your name, your address, who owns the copyright, like if you own it. So if it was a work made for hire, believe it or not, that company that hires you is gonna file the copyright application and say that they own it. They're gonna and say that it's a work made for hire instead of you filing this. Year you created the work, the title, any photos and videos, you upload the photos and videos of the work itself too. Videos are a little tricky. The portal doesn't have a lot of upload ability, so sometimes you have to like file the application and then mail in like a thumb drive with the video. And then the payment of the fee. And the goal again is to sort of create this catalog of like, this is the name of the artwork, this is when I created it. If you go and search the copyright records online, you actually don't even get to see images of the artwork registered. You can just search by like name and like title of the art or the owner or things like that. And it just gives you essentially all this information except for actually what the artwork looks like, which is interesting. So it's just kind of trying to create this database as well. I get the question of like, how am I supposed to register my copyrights? Because there's thousands of things I created. This is like completely like this. I mean, no one can afford to do that, right? Artists that I've worked with, it's kind of like, think of your more important works, right? Think of maybe the things that you could, end up licensing out to other companies and other people to use. You would want to register your copyright. It can be done at any time. It doesn't have to be done immediately, but I'm going to talk about that timing issue and sort of how it works with legal rights. And even after you pass away, if the copyright hasn't expired, you can still, your estate and your heirs can do that as well too. They can still file it after you've passed away as well. And that happens a lot too when an artist has passed away and maybe their work is doing extremely well. Sadly, the family will register the copyrights that were never registered before. But yeah, it can be done at any time. And they have you can set up templates too, so it automatically kind of has pre-filled out all your information. So then at that point, all you really have to do is kind of update the name of the artwork when you created it and the images of the work of art too. So you can kind of easily get through it quickly. All right, so why do you need to register? It proves who owns the artwork. It is used as a piece of evidence of who owns the artwork. Again, I've talked about you can't sue. That's frustrating. And then it also allows you to ask for more money in a lawsuit and get more money back if you've done the timing right, okay? And again, it also, just as similar to the copyright notice, having a work registered with a copyright also prevents that innocent infringer, like, I didn't know that you were the owner of this, was protected. Well, I have a registered copyright, that doesn't matter. Why timing is important. If you have the artwork registered before someone infringes, you can get more money in that situation, and you have more leverage to push them to pay more. If you want to get something settled, you don't want to sue them, but you just want to get money out of them. So copyright infringement, you can get actual or what's called actual damages or statutory damages. So actual damages is money you can prove you lost. They sold 10 copies of works of your art, right? Actual means how much money they actually made off of that, okay? If you had timed the registration before the infringement happened, and you can prove that, then you can ask for statutory damages. So these are fines, okay? These range, if it's just sort of innocent, minimal, about $250 per act of infringement. It goes up from there, kind of the more bad the things were that person did, and if they willfully infringed, it can go up to $150,000 per infringement. So going back to that 5 Points case, he got popped with $150,000 per each artwork that he infringed. So because it was so willful and intentional. And also you get attorney's fees too. So attorneys, we work two different ways usually. One, you pay us by the hour, so how much time we put in. We're sort of billed in increments at an hourly rate. Or we do contingency. It means you don't pay us anything. If we win and are successful for you, we get paid a portion of the profits that we got for you and that we were able to win for you. When you have a case where the copyright was registered on time and we can get statutory damages, attorneys are more likely to do that the contingency fee because there's a better chance that there will actually be recovery. So we talked about what the copyright is, how powerful, and how this legal right is automatic for you. We talked about transferring it as a work made for hire, or you've signed some kind of document stating that you are transferring the copyright. And we talked about registering the copyright.